Okay, so as a reminder, research papers are due tonight by 11:59 p.m. in Blackboard. If you've already submitted it, you're good to go. If you haven't, just make sure by the end of today. So today we're going to talk about federal courts, a little bit about the court process, and of course, we're going to spend a fair amount of time discussing the Supreme Court. Okay, so this is the third branch of government, the judicial branch, that we are discussing today. In terms of how our legal system generally works, criminal law refers to a case where someone is charged with violating the law relating to something like health, safety, or morals. So, burglary, assault, rape, murder. In criminal cases, the government is always the plaintiff. The government always brings the charges in criminal cases. So it's the state of Texas versus someone, or the United States government versus someone. In civil law, the government could be the plaintiff or the defendant. And here, we're dealing with disputes between individuals, companies, and groups. Usually something like a violation of a contract, failure to provide services, and so on. So if you pay someone to build an in-ground pool at your house and you give them the deposit and you never see them again, that's a civil case. Or if your landlord won't give you back your security deposit, that's a civil case. So usually with criminal cases, although sometimes with civil, the prior case decision can help determine the outcome of a current similar case. So if you're looking at two similar cases of assault, the judge or the prosecutor may look at that previous case to determine how they should approach this particular case. In both civil and criminal cases, the Constitution can be cited. More often in criminal cases, they may talk about a violation of a Fifth Amendment right or a violation of habeas corpus when referring to a mistake in a criminal case. also various types of courts and rules that are put into place no matter what court level. A trial court is the first court that hears a criminal case. You can have your case tried before a jury, or you can choose to go before a judge. If you're not sure that a jury would be fair and impartial, or you're worried there's enough evidence a jury might convict, you might decide to have a judge hear your case instead. So that's up to the defendant. You go before a judge or you go before the jury. If you are convicted, you first have to appeal to your state courts. An appeals court doesn't hear witness testimony. It doesn't usually look at additional evidence. What it's usually doing is trying to decide, was there a legal error in the previous court's decision? If a mistake was made, then they can vacate the conviction and order a new trial. If evidence was not tested, if the defense team wasn't told about certain evidence, that can lead to a conviction being vacated. At the state and the national level, the Supreme Court is the final court of appeal. For most people, their case doesn't usually go beyond their state Supreme Court. They'll win or they'll lose, but usually that's the end of the line for most cases. In terms of the idea of original jurisdiction, federal courts have original jurisdiction if a case involves federal law, treaties with another country, a case involving the Constitution, or where the U.S. government is a party in one of the cases. And the federal Supreme Court has original jurisdiction in a case where it's the United States government and a state, a case between two or more states. So if Texas sues New Mexico, that's going to go to the Supreme Court. A case involving a foreign minister or ambassador, and a case involving citizens from different states or citizens suing a foreign government. In those cases, it will go straight to the Supreme Court. At every single level, the right to due process is protected. The government cannot arbitrarily deny you the right to a lawyer, throw you in jail without charging you, torture you. They can't decide, we don't like your Twitter post, so you're going to jail. Due process exists at every single level, as does the right of habeas corpus. If you are arrested, you have to be brought before a court and charged with a crime. Authorities have to show just cause to hold you. You have to be charged with a crime. If you're brought to a court and a judge says there's clearly not enough evidence, then you are supposed to be released. You can't be held indefinitely. They can't arrest you on shoplifting charges and then say you're guilty without proving it. The only time habeas corpus can be suspended is if there's an invasion or another civil war. Otherwise, that right is fundamentally protected and any violations have to be dealt with by the court. If you're arrested and you ask for a lawyer and they don't give you one, that's a violation of due process. All right, in terms of the number of federal courts that we have, between 2014 and 2015, they received a little over 376,000 cases. They do hear a lot of cases. There's 94 federal district courts and about 678 federal judges. Federal judges are appointed. They're nominated by the president and confirmed by the Senate. We don't usually hear about federal judges being appointed because they're not really controversial. We tend to pay attention to the Supreme Court, but not other federal courts. There are 11 regional courts, plus the Washington, D.C. Circuit Court, and 12 U.S. Court of Appeals. Each Court of Appeals has between 6 to 28 permanent judges, depending on the size of the court and their workload. Most cases are decided by federal courts. A challenge to a state law, a criminal case, if it's taken up by the federal courts, this is usually the end of the line. In most cases, the decision is final unless the Supreme Court decides to hear it. But because that's exceedingly rare, it's rare for your case to get taken up by a federal court to begin with. It's even more rare for the case to get moved up to the Supreme Court. For example, challenges to state abortion laws, usually it's a federal court that hears it and overturns the state law. It doesn't usually go higher than that. All right, so now we're going to talk about the big kahuna, the Supreme Court, right? The court that tends to be considered the most when we talk about federal courts, the one that we pay the most attention to. There are 8 associate justices and 1 chief justice. The number of justices is controlled by Congress. It used to be 6, now it's 9. So this is partly why they were asking Vice President Biden, would you increase the size of the Supreme Court to deal with controversy? Congress could choose to appoint 2, 3, 5 more justices if they want. 9 is the number it's fixed at, but that doesn't mean it's permanent. Obviously, you want there to be an odd number so you don't have issues with the court deadlocking. The Chief Justice presides over the court's public sessions. He, current Chief Justice being John Roberts, is the first to speak and the first to vote when the justices deliberate. However, their vote does not count for more, and they have no more authority than the other justices during the deliberation. He can make an argument, but that doesn't mean the others have to fall in line. Again, Congress does control the number of justices. If Democrats somehow manage to take control of the Senate, as well as the House of Representatives, there's been some debate about increasing the size of the court. Whether or not that's going to happen, that's up in the air. That's going to be up to Congress to decide if they want to increase the size of the court. Okay, so with the Constitution, the way it works is that the President nominates a judge, and the Senate then has to confirm. It only takes a simple majority vote. You only need 51 to confirm a justice. And it's a very partisan process. Senators will tend to support a nominee from their home state. There's no real formal qualifications to serve on the Supreme Court. Usually they want someone with extensive legal experience, good character, and more recently, someone with the same ideological views as the president. It didn't used to be the case necessarily, but unfortunately it's very much the case now. You see Democrats trying to keep conservative justices off the court, and Republicans trying to keep liberal justices off the court. So it's no longer a question of, is this the best person? It's a question of, well, do they match our party's ideology? And this partisanship has made it harder to look at Supreme Court justices. Justice Thomas was nominated by President George H.W. Bush, and he was accused of sexually harassing an employee named Anita Hill. And I'm going to show you guys a video of her testimony before the Senate in a minute, but it got really, really, really ugly. And yet he was still confirmed to the Supreme Court. And in 2016, when Justice Thomas died in February of 2016, President Obama nominated Merrick Garland, who is a moderate, well-liked judge, to be Scalia's replacement, but Republicans in the Senate said, we're not holding confirmation hearings until after the election, which is nowhere in the Constitution, but there you go. So Garland was not put on the court. We got Gorsuch, Kavanaugh, and of course, very recently, Amy Coney Barrett. Yeah, I mean, there was a bit of hypocrisy, especially with the opening after Ginsburg died and Republicans going, we have to fill the seat. To be fair, Democrats would have tried the same thing if they were in power, so it's just become way too political. Alright, so I'm going to show you guys Anita Hill's testimony before the Senate Judiciary Committee in 1990, I believe this was 90 or 91. I recognize some of the members of the. These are some of the outrageous, ridiculously awful questions that she got asked during this whole process.
Welcome, Professor. You tell the committee what was the most embarrassing of all the incidences that you have alleged. You testified this morning that the most embarrassing question involved, it's not too bad, women's large breasts. That's the word we use all the time. You testified, you drew an inference that Judge Thomas might want you to look at pornographic films, but you told the FBI specifically that he never asked you to watch the film. Is that correct? The fact is, flatly, he never asked you to look at pornographic movies. It's not too bad. Did Thomas like to discuss specific sex acts and frequency of sex? You said you took it to mean Judge Thomas wanted to have sex with you, but in fact, he never did ask you to have sex, correct?
No, he did not ask me to have sex. He did continually pressure me to go out with him, continually, and he would not accept my explanation as one that would be valid.
So that when you said you took it to mean we ought to have sex, that was an inference, a mere allegation.
Senator, I would suggest to you that for me, these are more than allegations. These are the truth to me. These comments are the truth to me.
I'm not questioning your statement when I use the word allegation. I know about sexual harassment and discrimination against women, and I think I have some sensitivity on it. How reliable is your testimony in October of 1991 on events that occurred 8-10 years ago? How sure can you expect this committee to be on the accuracy of your statements?
I guess one really does have to understand something about the nature of sexual harassment. It is very difficult for people to come forward with these.
Got to know what your motivation might be. Are you a scorned woman? Do you have a militant attitude relative to the area of civil rights? Do you have a modicum of it? The issue of fantasy. Are you interested in writing a book? It is appropriate to ask Professor Hill anything any member wishes to ask her from the depths of her credibility. You are not now drawing a conclusion that Judge Thomas sexually harassed you.
Yes, I am drawing that conclusion. That is
I understand. But I don't understand. You have anything to gain by coming here? Has anybody promised you anything by coming forth with this story now? The witness did not say anything to the FBI about the described size of his penis, the description of the movie Long Dong Silver, about the pubic hair in the coke. I did think that Senator Specter pointed out some inconsistencies. All we've heard for 103 days is about a most remarkable man, and they scoured his every shred of life, and nobody but you has come forward. What you say this man said to you occurred. Why in God's name would you ever speak to a man like that the rest of your life?
That's a very good question. And I'm sure that I cannot answer that to your satisfaction. That is one of the things that I have tried to do today. I I have suggested that I was afraid of retaliation. I was afraid of damage to my professional life. And I believe you have to understand that this response, and that's one of the things that I've come to understand about harassment, that this response, this kind of response is not atypical. And I can't explain. It takes an expert in psychology to explain how that can happen. But it can happen because it happened to me.
It just seems that so incredible to me as the most contradictory and puzzling thing for me. I do not know how Judge Thomas defends himself.
I do apologize to the women of America if they got the wrong impression about how seriously I take the issue of sexual harassment. I must tell you, I must tell everyone else, I take sexual harassment seriously.
Yeah. Yeah. And he still got onto the Supreme Court anyway, but there was a lot of similarities with the whole thing with Kavanaugh, right? The questions about why didn't you come forward, how reliable is your memory? The thing with the Coke can, this is kind of gross, I realize. Supposedly he left a few big hairs of his around the opening of a Coke can that belonged to her. No idea why, I don't even want to know why, but yeah. Yeah. Okay. Yeah. So the Supreme Court has the ability to review laws and executive branch policies and executive orders. So in 2012, the Supreme Court did confirm that the Affordable Care Act was constitutional as a power of taxation by Congress. They did overturn the first so-called Muslim ban by President Trump. They said it went too far, so they have the power to do that. And if there's a question of state law versus federal law, they will use the supremacy laws to enforce federal law over state law. So in the Brown case, the Supreme Court said separate but equal was a violation of the 14th Amendment's Equal Protection Clause. They struck down school segregation because it did violate the 14th Amendment. So if federal law and state law are in conflict, usually the Supreme Court will uphold federal law over state law. Federal governments can also, the Supreme Court can also overturn redistricting if it's not done in a way that appears to be impartial. They overturned the Arizona State Legislature trying to redraw the districting map that an independent commission drew up. Also, if they make it too hard to vote, they'll strike that down. Arizona had passed a law saying that you had to prove citizenship in order to be able to register to vote, and the Supreme Court said that's too much of a burden, you can't do that. And they will look at questions of technology and review them as necessary. In the Riley case, the question was, is your cell phone protected under the 4th Amendment? And the Supreme Court said yes. That the cops need a warrant to search your cell phone if you don't give them permission. So if you are detained and they say, we're going to search your cell phone, you have the right to say, not without a warrant. And if they search it anyway, that's fruit of the poisonous tree and they can't use that evidence against you. So you do have the right to refuse to let them search your phone or your laptop without a warrant. And of course, over time, judicial review has been used to look at actions that violate the Constitution. In the Hamdi case, the Supreme Court said that presidential actions are subject to judicial review. In the Hamdi case, Hamdi was a Taliban soldier captured in Afghanistan and held at Norfolk Naval Base. He was actually born in the United States. He wasn't being given access to a lawyer or basic civil rights. So the Supreme Court said he's entitled to a lawyer. He is a U.S. citizen. You cannot deny him his rights. They have also said that habeas corpus is a fundamental right even for enemy combatants. You cannot hold someone indefinitely at Guantanamo Bay without a trial. And if you don't have enough evidence, you have to let them go. So habeas corpus applies even for enemy combatants. And over time, they have expanded the Bill of Rights to give us more protections. The Engel case, schools were having students, public schools were having students read from the Bible, recite prayers, and so on. So in 1962, the Supreme Court said that's unconstitutional. You're basically trying to force students to comply with Christianity, and you can't do that. That's why in public school you can't have prayer resuscitation, mandatory Bible readings, and so on. Of course, they've also expanded our rights. In Gideon v. Wainwright, they expanded our Sixth Amendment right to have access to a lawyer even when we can't afford one. Miranda v. Arizona is an expansion of the Fifth Amendment, protecting us from self-incrimination. Over time, the Supreme Court has reinterpreted the Bill of Rights as necessary to give us fundamental protection. Now, there are some limits on what the Supreme Court can do. They can't handle a hypothetical case on proposed legislation. So the law already has to have been passed. The executive order has to have been announced. They can't take on a hypothetical because you don't necessarily know what the legislation will do until it's enforced. Also, if the Supreme Court is going to hear a case, then the parties in that case have to have a personal or economic stake in the outcome. For example, when Anna Nicole Smith's husband died and left her most of his money, the children sued to vacate the will and keep her from getting the money. She had standing for the Supreme Court to hear the case, and eventually they sided with her. So both parties had a substantial economic stake in the outcome. Also, the case still has to be relevant or in need of a solution. We're not going to hear the case if the facts have changed or if there's been some other type of resolution. The exception to this was the Roe case. In Roe v. Wade, Roe had given birth by the time the case went to the Supreme Court. So the state of Texas tried to say, well, it's no longer necessary because she's given birth. And the Supreme Court said, pregnancy is roughly 9 months. The appeals process can take a couple of years. Therefore, we still need to resolve this. It doesn't matter that she's given birth. The question is still important. So in some cases, they will circumvent the mootness. But most of the time, some of the facts of the case of Jay won't hear it. If someone wants their case heard by the Supreme Court, they have to file what's called a writ of certiorari. In this case, at least 4 of the 9 judges have to agree to hear a case. If an individual wants to appeal their case to the Supreme Court, they have 90 days from the lower court decision to file this petition. After the petition is filed, it's presented to the clerks, who then give it to the justices who are participating in a pool. So you've got to get legal justices to look at the petition. And then, of course, you have to get them to decide to hear the case. In reality, only about 1% of cases that get filed every year are heard by the court. So there has to be a special and compelling reason for the Supreme Court to hear this case. Otherwise, they're not going to hear it. There's a variety of different factors that go into the case being heard in the first place. If the government is one of the parties in the case, then the Solicitor General will screen the case prior to it going to the Supreme Court. If an agency wants to appeal the case to the Supreme Court, they have to get the Solicitor General to sign off on it. If he or she does not support the appeal, then the Supreme Court won't hear the case. So if the EPA is being sued and the Solicitor General doesn't support the case, then the Supreme Court probably won't hear it. And of course, there's always going to be individuals and groups who are interested in the outcome of the case. They can file what's called an amicus curiae brief. They can file a brief with the Supreme Court and say, we really want you to hear this case. Here's our reasoning for why you should hear this case. Here's the decision that we think you should make. So if there's a lot of groups who are interested in the outcome of the case, then it is more likely that the Supreme Court will hear this case. There's also the role of the law clerks. Every justice gets 4 law clerks. These are the students, top law students from the top law schools, Harvard, Yale, Stanford, etc. So they'll look at the briefs, they'll provide their opinions on the cases. And we've had multiple Supreme Court clerks who have gone on to become Supreme Court justices themselves. So they are very influential because they work day to day with their justice. They know their opinions on the law, and so they can help try to persuade them to hear a particular case. 2 of the most active interest groups on the Supreme Court are the NAACP and the ACLU. So the NAACP will combine cases as necessary. Brown versus the Board of Education was the result of 4 separate lawsuits combined into one case by the NAACP, where they funded the court costs, the lawyers, and so on. So if there is a civil rights issue, the NAACP will get involved. If it's a civil liberties issue, the ACLU tends to get involved. If a major interest group like these two gets involved, the odds that the court will hear it go up even more, because there's a lot of recognition of the importance of the case. Okay, so if the Supreme Court decides that they will hear a case, the attorneys will file a brief explaining why the court should rule in their favor, and they'll cite previous decisions relating to the case and say, you sided with this person in a similar case, or you said this wasn't relevant in this case. Interest groups can also file the amicus curiae briefs to try and support the parties in these cases. Once the case is taken up, there's an oral argument before the Supreme Court. Each side gets 30 minutes to present their case. It is not 30 uninterrupted minutes. They are constantly interrupted for questions. Scalia used to interrupt all the time. Thomas very rarely. They have to be able to get their point across as quickly as possible. Oral arguments are audio recorded. No television cameras are allowed inside the Supreme Court. Kind of a way of protecting the justices. So there's the written brief and there's the audio recording, but no television cameras have ever been allowed inside the Supreme Court. People are allowed to attend the oral argument. If you happen to be in Washington, D.C. when the Supreme Court is in session and you can get in, why not, right? Why not go see them in action? After the oral arguments, justices retreat to the private meeting quarters and go into conference. This is where they have to decide the outcome of the case. Of course, you have to get a majority. It can be as close as 5-4, it can be 6-3, 7-2, etc. So they have to make their decision, and this part takes quite a while. They can be discussing a case for a couple of months. They can be going backward on the merits of the case. Once they have reached a decision, then the opinion has to be written. Supreme Court decisions have a monumental impact on cases all the way down the line. And they said if you have the fundamental right to a lawyer, that had to get filtered down to every state and local government. The people will look very, very closely at the court's decisions, understand how to interpret the decision, and look at it for future cases. These are very carefully written, very specific in their language. The majority opinion, usually it's signed by the Chief Justice. If the Chief Justice is on the losing side, he'll pick someone from the majority to write it. To get the majority opinion, the justices will also write a dissenting opinion. They can let people know, look, some of us agreed with you on this. You weren't friendless on the court. They can say, my colleagues clearly did not make the right decision. The dissenting opinions tend to be longer because they're hoping that when a similar case comes up in the future, their colleagues will side with them the second time around. Both opinions are written and published, and you can see them on the Supreme Court website. You can read through the entire decision. So, with the Obergefell case, Justice Roberts dissented and wrote a dissenting opinion that the 14th Amendment was never intended to provide marriage rights, let alone same-sex marriage. He accused his colleagues of misinterpreting the Constitution, going too far. So sometimes they can get angry, they can get annoyed. They do try to be careful in their writing because they don't want to be like, my colleague is an idiot, right? They're going to be careful in how they say things, but they're going to make it clear they don't agree with the majority. So if there happens to be a vacancy on the Supreme Court or a justice has to recuse themselves, if the court deadlocks 4-4, it goes back to the lower court decision. So sometimes that happens. And in that case, it just goes back to the lower court decision, and that's the end of it. What are some of the factors that play a role in deciding? Sometimes it can be something as simple as presidential pressure. The Supreme Court kept striking down the New Deal program during Roosevelt's administration. And he got so annoyed, he said, you know what, fine, we're going to add 6 new justices to the Supreme Court who are going to side with me. And the Supreme Court saw how angry he was and took a step back and stopped striking down the New Deal programs. The Supreme Court essentially saved itself from court packing by backing off and agreeing not to overturn New Deal programs. There's also the role of the justices themselves. The more conservative justices like Thomas and Kavanaugh and others tend to look at very strict interpretation of the Constitution. They see the Constitution as set in stone. They will argue that court decisions have to be based on a very strict interpretation of the Constitution. They will also say, if it's not in the Constitution, then we don't have the right to review the case. The more liberal justices like the late Ginsburg, also justices like Kagan and Sotomayor, look at the Constitution and say, look, the Constitution has to change with time. Slavery isn't legal anymore. Women have the right to vote. The Constitution has to be reinterpreted as necessary. They also argue that you need to look at the social impact of a decision. Roe v. Wade. The social impact of giving women control over if they had children was a monumental decision. For liberal justices, they look at that and they say, this was clearly the right decision because it changed women's rights. The more liberal justices will say, the Constitution's over 200 years old, we've got new technology, new ideas, society is constantly changing, we've got to reinterpret the Constitution as necessary. And of course, it does make a difference how partisan Congress is. I'm sure the sitting Supreme Court justices didn't love what they saw with the confirmation of Justice Barrett, right? How quick it was, how nasty it was, and how partisan it was. They don't like to see the court being used for political means, but they can't really do anything about that, so they just have to watch and see what happens. Of course, the court is limited in what it can do. They have to wait for a case to be heard to exercise their power. They're not going to give their opinion on an executive order or a proposed law, because that's overstepping their power. They can't do anything about it until the case comes to the court. So you'll notice that Supreme Court justices are careful not to criticize the president, not to criticize Congress, because they don't want to be seen as biased prior to a case reaching the court. There's also a tendency to help individuals, not social groups. There are exceptions like Brown and Obergefell. For the most part, they're handling an individual case, an individual complaint of civil liberties violations, an individual complaining about a civil rights violation. It helps a person, but it doesn't necessarily help everyone. And the court is very careful in how they word the decision to make it clear that it only applies to this certain case, for this certain circumstance. And they don't have the power to enforce their own rulings. They can't send the military out to enforce their case. In the 1800s, the Chief Justice ordered Georgia to release 2 missionaries that the state had arrested on Cherokee land. Georgia refused, and President Jackson said, "I'm not doing it." If President Eisenhower had said, "I'm not going to enforce Brown," then school segregation might have existed until the 1990s. The Supreme Court can't enforce its own rulings. It relies on people to respect their authority and to respect their power. That's not always the case. Again, the President and Congress can shape the court. Right now, it's leaning conservative. In 10 years, maybe it'll be more liberal. They go back and forth on it. But the court can't shape itself. They're dependent on who's in charge. So they don't get any real say on who gets added to the court. You just have to wait and see what happens. The court has been expanded over time. They have changed policies and powers. In the 1960s, they gave us more freedom of speech, protection from self-incrimination, the right to a lawyer, the right for women to have access to contraception. And in the 1970s, the court ruled that interest groups can sue a federal agency. So Greenpeace can sue the EPA if they're not doing their job. Consumers' rights group can sue the FDA if they won't pull a dangerous product from the market. So it's given us more of a right to go after federal agencies that aren't doing their jobs, rather than having to wait for the government to regulate itself. They've also engaged in what's called fee shifting. If you successfully sue a public official for violating your constitutional rights, you can get fees and costs from the government. They can be forced to pay for your lawyer. If you were wrongly imprisoned for 30 years, you're probably going to get a settlement from the government for that, because they're not going to want you to sue them again. So they may offer you something like $500,000 if you promise not to go after them again. So in that sense, we do have more of an ability to hold them responsible financially as well. You can't get 40 years of your life back. but you can have a decent start at rebuilding your life. You also have the ability to engage in a class action lawsuit. A group of individuals with a common interest or common ailment can sue on behalf of everyone who shares that problem. The federal judge in New York gave Vietnam veterans a certification as a class with the ability to sue the manufacturers of Agent Orange for the various health problems they faced. Agent Orange was a chemical defoliant used to destroy the jungles of Vietnam. It also caused high cancer rates, birth defects, and permanent damage to the veterans and their families. So they were able to sue Agent Orange for misleading them on the chemical, and millions of dollars have been paid out in settlements. That's why you'll see those ads like, did you use Johnson & Johnson talcum powder and get cancer? That's allowed. If you were negatively impacted by a product, you can join a class action lawsuit. And that's not necessarily a bad thing, because sometimes you don't even have to pay for a lawyer, right? Sometimes you're automatically entered into one of those and you get a settlement. So it's a way to hold companies responsible. And while they can't necessarily force someone to comply with their decision, they can penalize them financially until they agree to buy. In 1985, the NAACP sued New York City for refusing to build public housing in predominantly white neighborhoods. The NAACP won. New York City wouldn't build the public housing as required. The city was eventually fined $1.6 million until they gave in 2007 and agreed to abide by the ruling. To save themselves a couple of decades and $1 million by complying in the first place, this mechanism of the police making sure they're actually going to do it, poking them with a stick. As a way to pull dangerous products off the market, the manufacturers of Zantac recently announced that their product was causing stomach cancer and other cancers in people who use them long term. That's been pulled from the market. That Escher that I was telling you about, the tubal ligation that was causing hysterectomy, that's been pulled from the market. So it's a good thing in a lot of ways, because we can at least make sure these products aren't being given to people anymore. All right, any questions? Okay. So let me ask you guys this. Do you think the Supreme Court has become too political these days? Too tied to the partisanship that we see in the federal government? Sort of. Should we change the way we put justices on the court? Because it's up to the majority party in the Senate. Should we maybe look at changing that? One of the suggestions I've seen is create an independent panel of former judges to review potential nominees and then decide based on the highest qualified, most experienced candidate, regardless of party affiliation. The other thing we could possibly do is change it from a simple majority to a two-thirds majority, and say you can't appoint someone to the Supreme Court unless you get a two-thirds majority. Then you can't just put on liberals or conservatives. You have to get someone who would be by consensus. When Ruth Bader Ginsburg was appointed to the court in 1993, I think the final vote was like 94-6. I mean, very, very high support. You wouldn't get that these days. I mean, that's just not going to happen. Which is unfortunate, because it should be very clearly this person is qualified, this person should be serving on the court. So it's unfortunate that the court is now caught up in partisanship when it's supposed to be above politics. That's kind of unfortunate. Okay, so again, research papers are due tonight by 11:59 p.m. in Blackboard. If the Dropbox isn't working for some reason tonight, just let me know, and you'll be fine if it's not working. Any last minute questions on the paper? No, everyone's good. You're just ready to turn it in and be done with it? Okay. So we're going to talk about social policies like taxes on Thursday. Read the first half of chapter 16. Again, make sure I get your research paper by the end of the day. If you have any questions, you can email me or call or text me. Otherwise, enjoy the rest of your day.